Welcome back to the Thursday edition of The Attitude with Arnie Arneson and producers Dave Scott and Stephanie Collins. We continue to record on Wednesday morning. Well, we are up to episode 9 of Race Class. We have been discussing critical race theory and the whole sort of history of racism in America with Professor Jonathan Feingold since January of 2022. We'll continue to do this through December of 2022 unless I can convince him to do it for another year. But let me remind you why we're doing this. Legislation restricting the teaching of race and racism in public schools and government entities has spread across the country. In an effort to respond, Boston University law professor Jonathan Feingold and Arnie Arneson, myself, on WNHN are offering Race Class, a once-a-month course conversation where listeners can hear what it's like to approach race and racism from a place of curiosity and history rather than fear and anxiety. You can grab Race Class the last Thursday of every month. It's heard at 12:30 on the dial in Concord, New Hampshire, also streaming live. It is also available by podcast. It is separately podcast as Race Class. It also goes up on audio port. But I just want to remind everyone that in describing the foundational purpose of Race Class, Arneson and Feingold note, quote, "We know race matters. Part of this project is to make sense of what that means." So let me welcome back to the program, Jonathan Feingold. God, episode 9. We've been doing this for a while, Jonathan. Thank you so much.
Thank you, Arnie. As always, it's nice to be here. After a summer when we were doubling up over the past 3 months, it felt like a long time in between visits. And so I'm really glad to be back. Yeah, to kick things off today, I want to just refer back to the past 3 months where we had 6 episodes, which turned into what I thought was a really nice little mini series on affirmative action. And the upshot, I think, that one could fairly draw is that if the goal in university admissions is a fair, individualized, and merit-based process, then that just means you have to take into account all relevant factors. Right. One highly relevant factor is race. Whether or not we want it to, race remains a central organizing force in America that shapes almost every, if not every aspect of our public and private lives. And so what that means is that if we go, quote unquote, colorblind, we don't allow ourselves to see race, if we don't allow ourselves to see racial inequality, then that guarantees us a system that rewards those with the most inherited racial advantage at the expense of everyone else and at the expenses even, just basic commitments to admitting people on, just based on who has the most academic talent and potential. And I say that in part because one of the reasons we had that mini-series is because in almost exactly a month, the Supreme Court will hear oral argument in 2 cases that challenge and will likely be the end of affirmative action in higher education. Both Harvard and UNC, we've talked about at relative length, are defending their right to consider an applicant's racial identity. And we know where this case is going to land. Maybe not precisely how, but I'm really confident about this, in part because I think we know the court at this point. The Supreme Court is going to side with anti-affirmative action activists who have literally, and I don't mean literally in the figurative sense, but I mean literally, bankrolled decades of litigation designed to roll back civil rights remedies, like affirmative action, in order to stymie civil rights. It's not just what the Supreme Court's going to do, it's the rationale that they are going to offer. The Supreme Court will tell us that the decision is necessary in order to be faithful to the 14th Amendment, Brown v. Board of Education, and Title VI, federal anti-discrimination law that was part of the Civil Rights Act of 1964. And so our inquiry for today, especially with, I imagine you have many listeners who have Dobbs in the back of their mind or in the forefront of their mind. Understand it as a quite lawless opinion that played quite cavalierly with facts and history in order to dispense with settled law and, just produce an ideologically motivated result. But so with that in the back of our minds, where does the Supreme Court decision or the affirmative action decision that I just previewed, where does it stack up Is it more activist than Dobbs? Is it less activist than Dobbs? Is it the same? And so that's our inquiry today.
You're asking the question in relationship to Dobbs? I looked at your outline, and it looks like it's been a pattern and practice with this court. Now, this is not a one-off, because if you actually go look at what the court has done, for centuries, their tendency is to do exactly what you are predicting they will do with affirmative action.
And so I asked the question, and I posed the sort of juxtaposition with Dobbs for a couple reasons.
Okay.
One is that when Dobbs came down, the general narrative was, this is a court that is lawless. This is a court that is not faithful to the Constitution. It's a court that is faithful to a very extremist, religiously inflected project. And so the question, and I don't think the public, I don't think the media will read the affirmative action decision. I don't think they will talk about it in the same way. And I think descriptively, that's misguided. Because this decision, this affirmative action decision coming down the line, assuming that I'm not wrong, I would gladly be wrong about what's coming, it is going to, in a sense, be the penultimate capstone, because I think something is coming next after this, to about 150 years of what I am referring to as an activist Supreme Court, in the sense of a Supreme Court that has been unfaithful to the Constitution. And I really mean the Constitution born out of the Civil War, and hostile to racial justice. And that's, maybe a big claim, but I think there's quite a evidentiary basis to it. For anyone who wants to hear the case that I'm making in, 25,000 words, Brandon Hasbrook, who's a law professor, wrote an incredible article published by the Boston University Law Review called The Antiracist Constitution, in which he excavates a history that reminds us that the problem today, when it comes to realizing it, reckoning with our history, and actually remedying racial inequality, the problem isn't the Constitution. The Constitution, if we were faithful to it, if we were faithful to its original public meaning, were we all actually originalists, the Constitution would invite, if not compel us, to engage in a whole range of what we might consider quite radical anti-racist remedies. So, with that, let's do some time traveling.
I want to do some time traveling, because when I was reading about the 1883 civil rights cases where SCOTUS strikes down an anti-discrimination law, I read the paragraph that you sent me and I started to scream, because I could just see how they were sort of warping their logic to sort of justify their actions. But it is just, they were so malleable and so not consistent with what I think you were just saying about the Constitution.
I think one can fairly say that there have been maybe 3 moments in our country's history in which we have aspired, through laws that we've passed or constitutional amendments that we've adopted, that we've aspired for something that you might call radical democracy. Like just the notion that we actually want to live up to everything that we say about ourselves. And the first moment, and maybe the first moment is sort of a series of moments, but I will encapsulate it in the ratification of the 14th Amendment.
Okay.
And so this is 1868, a few years after the Civil War has ended, in which the North has ostensibly won, though now we have to ask, who actually won. And in 1872, so just a few years later, in the slaughterhouse cases, which is notorious for a reason that we'll get to in a little bit, the Supreme Court, so a court that's privy to the Civil War, privy to the 14th Amendment in ways that none of us are, at least that court suggests that no one can fail to be impressed with the one pervading purpose found in them all. That is, all of the Civil War amendments, the 13th, 14th, and 15th, lying at the foundation of each, and without which none of them would have been even suggested. Mm-hmm. We mean the freedom of the slave race, the security and firm establishment of that freedom, and the protection of the newly made freemen and citizen from the oppression of those who had formerly exercised unlimited dominion over them. That strikes me as a bold, ambitious constitutional amendment that is meant to transform the Constitution.
Yes.
It's meant to give us a document that we did not have before, for reasons that the late Thurgood Marshall invoked when he stated at his bicentennial address in 1987 that the Constitution did not survive the Civil War. The Union did, but the Constitution did not, because the Civil War gave us a new Constitution, one that was committed to, what we might think of as radical democracy.
Right.
We know, though, that that promise was short-lived, and so let me jump now to our second moment of, what we might think of as radical democracy, and that is Brown v. Board of Education. Footnote, a lot of ways that one can critique Brown as not actually going far enough, not as misidentifying a symptom of white supremacy for the disease itself. Nonetheless, it is a radical moment that strikes down at a pillar of Jim Crow and chops away at Plessy. It is only made possible by mass mobilization, decades of litigation, and a geopolitical context that, in which, as individuals like Derek Bell have identified, made segregation no longer sustainable for, America's white ruling class for various reasons. So that's the second moment. And the third is the Civil Rights Act of 1964. There's, obviously one could name other moments, but these are three that are key for reasons that we've said and that I'll say again. Congress passes the Civil Rights Act, contains a number of provisions, including public accommodations law that prevents theaters, restaurants, train stations from discriminating on the basis of race. And in a second, we'll ask why we needed to do that. And it has a provision known as Title VI that prohibits discrimination on the basis of race by entities that receive federal financial assistance.
Right.
So why did we need the Civil Rights Act? Why do we need all these provisions? Well, with respect to Title VI, part of the reason was that Congress needed a way to enforce Brown's mandate to desegregate. Because 10 years after Brown v. Board, the South, in explicit ways, through raising arms and, in every other measure, said no. Essentially, said no. Sorry, Supreme Court, don't care. Don't like the opinion, you're illegitimate. Sorry, we're not moving. And so Congress and the courts begin to reassert authority. Civil Rights Act's one way to do it. Civil Rights Act barely passed. Yeah. It survived the longest filibuster in Senate history. I think 75 days or so when you actually still had to talk to filibuster. At the time, I believe it was only the fifth civil rights law ever passed by Congress. Only after, it survived filibusters that today you don't even have discussion about. So little history, three moments that I think you can fairly identify as attempts by this country to codify laws that are designed to bring us closer to our highest aspirations of a radically democratic multiracial union. Why do I name those three, that constitutional amendment, that Supreme Court decision, and that federal law? Because when the Supreme Court says, Harvard, you may not consider race to maintain an integrated campus. When it says UNC, you may not consider race to overcome your ongoing and deep-seated legacy of racial exclusion, the Supreme Court is going to point to those three moments and say that those are the reasons why we cannot engage in what is in every respect just a modest manifestation of what everyone was asking for in the summer of 2020. How can we What is the anti-racist policy? What can we do to reckon with this reality? The Supreme Court is going to step in and say, so you can't do it. And it's going to point to the most, our most radical aspirations. And so I'm going to pause. I'd love for you to jump in and hear any reactions.
They're going to use these radical aspirations as cover for why they're going to take away from UNC and Harvard the ability to embrace affirmative action that recognizes race. So they're going, I mean, it's almost, I can't use the term on, but it's a mind F, because it's like what you think would be the encouragement of affirmative action. Now they're using those same positions to say, no, it undermines affirmative action. Therefore, affirmative action is basically, are they going to find it unconstitutional because of these three things that you just pointed out? Is they going to sort of go that far to say that you can consider it because it violates the 14th Amendment?
Yes, the Supreme Court is going to say that what UNC is doing is unconstitutional because of the 14th Amendment. The Supreme Court will say what Harvard is doing is unlawful because of Title VI, because Harvard is a private entity, not a public university. And so the Supreme Court is going, and we don't have time to talk about the full, like the past 70 years and 50 years of a more piecemeal strategy to get to this point, and to do so in a way where, again, I do not think that most of the public or the media will experience this decision in the same way that they did Dobbs, as a moment of lawless infidelity to the Constitution, that is really just meant to further an anti-democratic and anti-civil rights agenda. But so let me just, give us a few more sort of pieces that we can play around with. So I'm making a pretty bold claim that the Supreme Court has been unfaithful to the Constitution, particularly with respect to the 14th Amendment and also the 13th and 15th Amendment, but laws that were part of the most racially progressive, radical moment in our history. And the Supreme Court does this in three different ways. One is by striking down racially progressive laws. You referenced this before, we'll name it in a second. The second is by neutralizing or diffusing laws that are designed to stop racism writ large by making them, inert. But the third, and this is what we're going to see in the affirmative action case, is actually co-optation of these radically progressive laws for radically regressive purposes. Because what the Supreme Court is going to say is that it's not just that an institution might have a mandate to reckon with the history of racism. The Supreme Court is saying it's impermissible to. And so let's just, we'll walk through some examples. So what's an example of the Supreme Court striking down a law designed to advance democracy and racial justice?
Let me just say something. This section blew my mind. Because when I watched the mental gymnastics of what they went through to strike down an anti-discrimination law, I was both shocked, but at the same time, as I was reading it, I could see how it sort of forecasted exactly what the Supreme Court would be doing, as you just described, even with affirmative action, because it lays a foundation for how they sort of manipulate what they ultimately want, which is an outcome that you and I know, frankly, is not what the fathers envisioned, or frankly, what the Civil War envisioned. We know if you're going to free people, then recognize, what does freedom mean?
And, a different sort of question is either thinking about sort of that Reconstruction period after the Civil War or post-Brown. Is the remedy to Brown, or the remedy to the harm that is underlying Brown, the constitutional violation that is giving rise to Brown, is the remedy just eliminating all of the formal policies that said, if you are not white, you might go here? The question is, have we achieved what Brown demands just by formally opening the schoolhouse door?
Right.
And we know that never has it been the case where just formally opening the schoolhouse door, or by law making it unlawful to enslave by prohibiting slavery as a matter of law, we know that's never been enough because the formal law, the formal policy was, it was part of the infrastructure that propped up a broader system. It wasn't the infrastructure. In 1875, a decade after the Civil War, Congress is trying to figure out how to actually realize this promise of a union in which everyone has some semblance of, equal citizenship. And I'm using citizenship not in a technical term, but just like equal membership of the society. And Congress recognizes that one of the barriers to full citizenship is all of the private discrimination that non-white people, black people, among others, face. And so Congress passes the first federal anti-discrimination law that today we would just take for granted. And the Supreme Court strikes it down. The Supreme Court strikes it down on the basis that Congress lacked the authority pursuant to either the 14th Amendment or 13th Amendment to regulate, quote unquote, private conduct. Yeah, go ahead.
Is there rationale? I literally, this paragraph screams at me, and I just want to read it because I think it's too important. When a man has emerged from slavery and by the aid of beneficent legislation has shaken off the inseparable concomitants of that state, there must be some stage in that progress of his elevation when he takes the rank of a mere citizen and ceases to be the special favorite of the laws. And when his rights as a citizen or a man are to be protected in the ordinary modes by which other men's rights are protected. There were thousands, this is the amazing gymnastics. There were thousands of free colored people in this country before the abolition of slavery, enjoying all the essential rights of life, liberty, and property, the same as white citizens. Yet no one at that time thought it was any invasion of their personal status as free men because they were not admitted to all the privileges enjoyed by white citizens, or because they were subjected to discriminations in the enjoyment of accommodations in inns, public conveyances, and places of amusement. Mere discriminations on account of race or color were not regarded as badges of slavery. Oh my God, Jonathan, I read that paragraph and I'm like, are you kidding me? This is how they were able to strike down that anti-discrimination law. Just because we don't let them into a hotel or a motel or to a restaurant, before we abolished slavery, and no one complained about that had nothing to do with slavery, i.e. being black, i.e. being discriminated. Therefore, we don't have to protect, we don't have to protect these individuals. And this anti-discrimination law, in fact, is false or unconstitutional. It's just amazing.
I want to just tease out a couple threads from this quote, because this quote is from a Supreme Court decision that was issued in 1883, so less than 2 decades after the Civil War. But we can still hear arguments that are made today against, for example, affirmative action. Mm-hmm. So the claim in this context that anti-discrimination law was going to render African Americans the quote unquote special favorite of the laws. That is the same argument we hear today against affirmative. It is, almost identical. And also how legislation that is designed to ensure the equality of one is then just articulated or re-articulated as an invasion of the rights of others.
Right.
And so we see this in all over the civil rights context, whether it's about the rights of trans people, whether it's about the rights of women, whether it's about the people of color, though laws that are designed to prevent discrimination against groups that have faced historical discrimination in this country are re-articulated as an invasion of other rights, now often in sort of the rhetoric of religious freedom or religious liberty. But this is a through line that we have been with for a really, really long time. And so we're almost out of time. So let me just quickly identify an example of the Supreme Court neutralizing laws that are designed to, realize radical democracy. One example is the slaughterhouse cases, which I pulled a quote from before. And that was a decision in which the Supreme Court effectively neutralized the privileges or immunities clause in the 14th Amendment. My sense is that almost no Americans have ever even heard of the Privileges or Immunities Clause. From the perspective of the folks on the ground at the time, that was the clause. Arguably, that was the one that was designed to be the most forceful, the most potent to ensure an actual transition from a state of formal racial hierarchy to one of equal citizenship. And with the stroke of an ink dotted pen, the Supreme Court, in the most of anti-democratic ways, intervened and has essentially written the Privileges or Immunities Clause out of the Constitution.
Oh my God. All right, we got to go. I'm telling you, reading that 1883 case, I was just screaming, going, but you're absolutely right. I'm reading these things going, it sounds like what this court is saying today. And we're talking the late 1880s. And yet I'm hearing a court in 2022 basically mirroring those same words. This is Race Class, episode 9 with Jonathan Feingold. Again, I want to remind you, we do this every month. And one of the reasons we're doing this is that we know race matters. And part of the reason for Race Class is to make sense of what that means. Thank you so much for joining me, Jonathan Feingold. I really appreciate it.
Thanks, Arnie.
This is The Attitude with Arnie Arnesen and producers Dave Scott and Stephanie Collins. We will schmooze tomorrow, everyone. Ciao.